Welcome to everyone who is going to spend the next 45 minutes or so with us. It's great to have you here. If there are any topics that you are particularly interested in, please feel free to let us know, and we will make sure to address them on the webinar in one form or another. So with that said, let's get started. So I am going to talk about COVID data, where we are now, and what we're looking for. We have been providing you this data over the past couple of weeks. The last time I presented 2 weeks ago, we saw that there was a sharp increase in new cases, at least in a certain part of New York State, in central New York State, where I'm located at Syracuse. We have seen now, if you look at this chart, you see the curve slightly starting to go up. Cases are up approximately 67%. Over in a rolling average over the past 14 days. Testing is up, hospitalizations are up. These are all not good numbers, not good statistics, things we don't want to see. But I can report that although there have been significant increases over the past 2 or 3 weeks, we still haven't seen any policy changes. Now, I'm sure many of you have read the news today and over the last couple of days that Philadelphia is reimposing its indoor mask rule. We haven't seen anything like that out of New York State yet, but as all of you know from attending this webinar in the past, I had a streak of luck where I'd present on something at noon on Tuesday and the state would change the rule at about 3 o'clock that afternoon. So to the extent there are any changes, we will certainly keep you up to date on those. Next slide, please. Just a little more data that I think is helpful to see where we are seeing an increase of cases and by how much. Onondaga County, where Syracuse is located, the last time I presented 2 weeks ago, we had an extreme increase in cases. Thankfully, we're down a little bit here. Over the daily average is down about 2%. But you can see in most of the other parts of the state, other counties, we are seeing a significant increase. You see that red there in Oswego and Jefferson counties, which is obviously not something that we like to see, but this is the information for you. Again, this will be available on our website tomorrow, along with all the other slides that our presenters utilize. So without further ado, let's get into the first substantive presentation today. I have received a lot of questions from clients about this new electronic monitoring law. It's a hot topic. And here today to talk to us about it is Travis Tallarico. Travis is an attorney in our Rochester office. Travis has been on many times before, so hopefully you know Travis, and if you haven't reached out to him, please feel free to do so. Travis, take it away.
Thank you very much, Adam, and hello, everyone. Happy to be here and happy to provide an update on a very topical law that is going to be going into effect in the near future. So figure this is a good time to address it and be proactive rather than reactive, and allow all employers on this call to start taking the necessary measures to gain compliance. So Kathy, if you want to get me to my first slide, we'll get into it. So a little bit of background. So this law was signed into effect or into law by the governor back at the tail end of 2021 and becomes effective as of May 7th. So this is going to be broadly applicable to pretty much essentially all employers in the state. The specific definition is that it applies to employers who monitor or otherwise incept their employees' telephone calls, email, or internet access as defined under the law. Now, taking a little bit of the legalese out of this, I think that this can be more readily understood by essentially any company that reserves the right to monitor its company's employees for any sort of substantive measures are going to be covered by this. So what do employers need to do is they, as of May 7th, they need to provide a written notice, can either be hard copy or electronic, to all employees upon hiring, and post a notice containing similar language regarding the electronic monitoring in a conspicuous place, which is readily available for viewing by all affected employees. Now, a little caveat here is that the law does not actually require the written notice or acknowledgement to be provided and obtained regarding current employees. but that notice still must be posted in the workplace. And regarding those current employees, I'll talk a little bit in a few slides about maybe some best practices on how to handle that. So what does the notice actually require? So there is some specific language that's provided in the statute that must be included in the notice, which is provided on this slide, but to just read that out. So the notice must advise employees, specifically using this language, that any and all telephone conversations or transmissions, electronic mail or transmissions, or internet access or usage by an employee by any electronic device or system, including but not limited to the use of a computer, telephone, wire, radio or electromagnetic, photoelectronic, or photo-optical systems may be subject to monitoring at any and all times by any lawful means. So obviously that's a mouthful, and I think a lot of us on the call might not even be fully aware of what an electromagnetic or photoelectronic method of communication particularly is, but that language does need to be included in the notice. And so the law further requires that employees acknowledge receipt of this. So would be a recommendation that employers are actually having employees sign off on the receipt of this form in some way, shape, or form. Next slide, please. So a few situations that the notice does not cover. So it does not apply to processes where the monitoring activity is either designed to manage the type or volume of the email, telephone, or internet usage, is not targeted to monitor a particular employee, and is performed solely for the purpose of computer system maintenance and or protection. So again, putting this into some more practical terms, I would interpret this to say if it's kind of general company monitoring of just sort of usage of, how many emails are being sent out a day, how many phone calls are being sent out a day, that would probably be is what this is, what this provision of the law is getting at. But any sort of, again, as I stated at the beginning of the presentation here, any sort of monitoring of specific employee communications or reserving the right to do so is going to require such notice. So there are some penalties that are associated with the law as it's currently drafted. So it does not provide a private right of action for employees, but it will be enforced by the New York State Attorney General. Failure for compliance could result in penalties of $500 for the first offense, $1,000 for the second, and $3,000 for the third and each subsequent offense. Now, we can't really look through a crystal ball yet and see exactly how the AG would plan on enforcing this, but just be advised that there are monetary penalties in relation to this law. So just a few other notable things is, and this actually is very important to take note of, is so the law does encompass bring your own device programs and is not strictly limited to employer provided devices. So if an employer is allowing employees to use their own personal cell phones for company related emails. So if there's an employee that has their company email on their phone, it's going to apply to them as well. It's not just strictly limited to company provided devices. Now, I just wanted to come up with a few what I think are some best practices moving forward before the law gets implemented to actually take into effect, and moving forward from there is be proactive and start drafting a sample notice to be provided in the workplace and to be provided for new hires. I would recommend starting to post that notice sooner rather than later. And also for the new hires, just make that a standard practice and provide the notice as part of all your standard new hire paperwork. I also think it's probably a good idea to go into employee handbooks. I presume that many employers on this call already have a section regarding usage of company equipment, emails, etc. But I think it would be a good practice to include specifically that language that I read off earlier in the presentation in the employee handbooks, just as kind of an additional way to cover some bases of notice for current employees. And if it is practicable, I think it would be a good idea to actively provide this notice to all employees, both new hires and present. Now, I realize this is probably going to, in terms of a practical effect otherwise, that this is going to have I'm assuming that a lot of employers are going to be having questions about this. They're going to receive this notice and start wondering, how that impacts their privacy implication, and may get them thinking a bit more about what their employer is actually looking at on a day-to-day basis. I don't really know if that has any particular legal implications, but I foresee it being something that employees are going to start talking about and start asking questions. So as you all proceed to implement these policies, any questions, please feel free to reach out to myself, anyone on this call. And I assume there's going to be a lot of questions on this over the next couple of months here.
Travis, that's very helpful. I know I've been getting a lot of questions about this. We are getting a lot of questions in the chat. One of the things people are wondering is whether this applies to public entities as well, public employers, and it does not. It says right in the text of the law that it only applies to private employers. So that question we can answer pretty easily. The other questions that you have that are specific to you and your situation, please don't hesitate to reach out to Travis. I will also point out that our blog, the Bond Schoeneck King Labor and Employment blog, has an article that was recently written, I think last week, on this topic that can provide you with some more information. Please feel free, again, to reach out to the authors of that blog or Travis. Okay, well, thank you, Travis. We really appreciate it. Next up, we're going to have Jennifer Sin on. Jennifer's an attorney in our Albany office. Jennifer is one of the leaders in our cannabis practice group that we have firm-wide, and she's going to talk about some proposed cannabis retail dispensary regulations that were recently issued. So Jennifer, welcome.
Thank you. Nice to be here. Thank you for joining, everyone. I'm going to give you a quick update. We've been, those of us in this practice area have been waiting for regulations to come out, and we've got some new regulations. So I'll just give everybody a quick update on that. So this is the New York Office of Cannabis Management's proposed regulations on adult use conditional retail dispensary licenses. So it's quite a mouthful. So just a little background. The Marijuana Regulation and Taxation Act was passed just over a year ago, back on March 31, 2021. We generally refer to it as the MRTA. And that's the statute that legalized the production, distribution, sale, and use of adult use cannabis in New York, adult use being differentiated from medical use. The MRTA also created the Office of Cannabis Management, the OCM, which is going to be responsible for issuing licenses and developing the regulations to govern the participation in the new cannabis industry in New York. Next slide, please. So the MRTA definitely had a large focus on social equity. A lot of provisions in that act about that, and it sought to address the issue of criminalization of communities of color and low-income areas in a number of ways. One was removing marijuana from the New York Controlled Substances Act. It created a process for addressing past marijuana-related convictions for things that are no longer going to be illegal. It directed that 50% of the tax revenue for the sale of adult use cannabis be used for community-based projects. And it also proposed that the first retail dispensary licenses in New York should be issued to individuals who were adversely affected by marijuana-related convictions. And so that's what these new regulations are largely dealing with. Next slide, please. So these proposed regulations came out just very recently, March 10th. They were put out by the Cannabis Control Board and the OCM, and they are still proposed. They're open to public comment. The public comment period ends on May 31st, so see what changes there might be between these proposed and the final. But once they do become effective, they're going to create and govern conditional adult use retail dispensary licenses, which I'm just going to call the licenses for the rest of this presentation. Next slide, please. So these licenses are going to be reserved for individuals who are disproportionately impacted by the war on drugs. And according to public statements that OCM officials have put out, we expect that these individuals, and I'll run through the qualifications in a minute, are going to receive the first 100 to 200 retail dispensary licenses in New York. And OCM is saying that they think they're going to be able to fast track this process and that these licenses should be issued, they're hoping, during the 2022 calendar year. Next slide, please. So to be eligible for this, first set of retail licenses, according to the proposed regulations, each applicant must demonstrate, one, that it has a significant presence in New York State, two, that at least one individual is what they're referring to as justice involved, which I'll define in a minute, and three, that the applicant holds or has held for at least 2 years a minimum of 10% ownership interest in or had control of a business that had a net profit for at least 2 years out of its operation. 501c3 entities can also apply for these licenses under certain circumstances. If they have at least five full-time employees, have justice-involved individuals on the board or as officers, and they meet certain other justice-related conditions. Next slide, please. So what is a justice-involved individual according to these regulations? There's a few different ways an individual can meet that qualification. One is that the individual themselves was convicted of a marijuana-related offense in New York prior to the time it became legal, which was March 31st of 2021. The regulations list a number of sections of the penal law that conviction could have been under, but it includes possession, sale, loitering while in possession of a controlled substance. Another way to meet that qualification is having a parent, legal guardian, child, spouse, or dependent be convicted of a marijuana-related offense, or being the dependent of an individual convicted of a marijuana-related offense. Next slide, please. So applicants also are going to need to meet certain ownership requirements. At least 51% of the applicant must be owned in the aggregate by one or more justice-involved individuals, and at least one of those justice-involved individuals has to own at least 30% and exercise control over the applicant. And the regulations do go on to make it clear that the percentage of ownership for those justice-involved individuals, it does have to be proportionate to that individual's interest in the capital assets, profits, losses, et cetera, to make sure that the justice-involved individual, their ownership percentage does match their actual involvement with the business. Next slide. So there are going to be some other criteria that are going to be considered. Now, we haven't actually seen any of the application forms yet. They haven't come out. But the regs do specify that in reviewing the applications, they're going to look at a number, the OCM is going to look at a number of things. Now, regarding the justice-involved individuals, they're going to look at whether it was the individual who was convicted versus a family member. And they also are going to be asking a lot of questions about the primary residence of the justice-involved individual at the time of the conviction. And some of the things they're going to look at as far as that residence are whether it was in an area with high rates historically of marijuana-related offenses, whether that area has a historically low median income, and whether that area has certain levels of public housing availability. Some factors that they're going to look at regarding the qualifying business are number of employees, number of years in operation, profitability, type of business. It looks like they're going to be giving some extra weight if it was a retail business versus another type of business. If it had a physical location and if it received any fines or violations. Next slide, please. And just a few other things to be aware of for anybody who's interested in possibly exploring this industry. These licenses are going to be for a conditional period. For right now, it looks like that's going to be 4 years. Licensees must be prepared to start actual operations no later than 12 months from the date the license is granted. Again, that's the interest in getting this all fast-tracked and getting the industry up and going. Licensees are only going to be able to acquire their cannabis products from entities that are authorized to distribute cannabis products in New York. And for the duration of that conditional period, the licensee must maintain the minimum standards for ownership and control. So whatever levels of ownership that those justice-involved individuals do have, the expectation is that will stay the same for the first 4 years. And after that end, that 4-year conditional period, the licensees may apply to transition to a regular adult use retail dispensary license. We don't have regs on those yet, We're hoping those will come out soon, but there is the expectation that the folks who get this first round, these conditional licenses, will have the ability to transition to the regular adult use retail dispensary license in the future. And licensees are going to have to enter into various agreements that are going to be approved by the Cannabis Control Board. And the key one of that is a labor peace agreement with a bona fide labor organization. And that's included in the MRTA as well. That is something that OCM is going to be focused on. So hopefully that was helpful. Be happy to answer any questions. And we're going to be monitoring very closely as regulations come out. We think that they're going to be coming, hopefully more regulations coming.
So Jennifer, this was passed in early 2021. We just got some regulations about who might be able to sell. At some point, it's actually going to go in effect, right?
Yes, yes. We've got some draft regulations on cultivation. We've got now these for the first set of retail dispensary licenses. And, you know, they're hoping that the application process might open as soon as this summer. Maybe that's a little optimistic, but we'll see.
All right. Well, thank you so much, Jennifer. And if anyone has any questions about that topic, make sure to reach out to Jennifer or anyone in our cannabis group. So moving on to our next topic, this is a very interesting topic. I have a number of clients on both sides of the equation, right? You're an employer, you want to protect your trade secrets, confidential information, so you want your employees to sign restrictive covenants, including non-competes and non-solicitation agreements, or you want to hire someone who may already have a non-compete in place, and you want to know if that non-compete would prevent you from hiring the employee. This is an issue that is all over the state, all over the country, really. And here to talk to us today about drafting enforceable restrictive covenants is Jeremy Scher. Jeremy is an attorney in our Rochester office and has a lot of experience with these issues. Before Jeremy starts, I do want to make one comment. We had a question in the chat about the proposed or potential restrictive covenant law that was included in the state budget. That is no longer part of the state budget. It wasn't part of the budget. And I don't know if Jeremy's going to talk about that, but I did want to mention that because it included some substantial changes to how you'd use restrictive covenants in New York. But with that long-winded introduction, Jeremy, welcome.
Thank you very much, Adam. I think that's an excellent point that the law on non-competes may change at any time because we're the only state right now that has no legislation whatsoever on protecting trade secrets or bans on competition. We're the only state in the country that still leaves this area entirely up to judges. So I think it is likely that sooner or later the legislature will step in and pass a law, but it hasn't done so yet. So let's go to the first slide. First of all, it's important to know what a restrictive covenant is. That's the term I'm going to use to describe all sorts of contractual agreements that protect an employer against competition from a former employee. What's important to keep in mind is that the courts, which again are the sole entity regulating restrictive covenants in New York state courts, see restrictive covenants as a way to prevent unfair competition. So judges have decided over time what constitutes unfair competition, which can be blocked through a restrictive covenant, and what constitutes healthy competition, which cannot be blocked. And judges routinely step in to decide whether businesses can enforce their restrictive covenants or not, depending on what courts have defined as unfair competition, which I will get to. There are three primary types of restrictive covenants, starting with the non-compete, which is simply blocking an employee after their employment ends from competing in a given field for a certain length of time in a certain geographic area. These non-competes have, I would say, fallen out of favor with judges, especially in the last 5 years or so, and are very difficult to enforce. And again, the legislature may step in to make them impossible to enforce, but currently they can be enforced only in very specific and limited situations. The next more permissive form is the customer non-solicit. This will prevent an employee from soliciting a former customer. Importantly, it has to be a former customer that has some kind of personal relationship with the former employee. It cannot be a customer that the employee never talked to while working for the former employer. It has to be someone with an established connection. These non-solicits tend to be enforceable if they're drafted a very particular way. And because there's no law on this, and you have to look at cases, it's difficult to know how to draft them. At the end, I'll summarize by saying this is an area where legal representation is very important. Finally, the most permissive kind of restriction is a non-rating or employee non-solicit restrictive covenant, and that prevents the former employee from encouraging their former colleagues to leave the former employer and join a new employer. That's the area where there's the least in terms of prohibitions by courts. Courts are most likely to allow this kind of provision, although again, nothing is certain. There's always the possibility that a court will strike down even a non-rating provision. Let's go to the next slide. Thank you. So it's important to know what restrictive covenants, what's the point of a restrictive covenant? So, and the way I would look at that is, what can an employee do after leaving your company if they don't have a restrictive covenant? Well, generally they can compete with you, and generally they can call your clients and solicit those clients and say, I'm at XYZ Corporation now, we can give you better service, and try to get your clients. That's typically allowed without a restrictive covenant. They can also probably call your employees too, and say, join me at XYZ Corporation. You'll get paid more, or you'll get treated better. So restrictive covenants are the way to prevent that kind of conduct. Again, assuming that a court will enforce your restrictive covenant. Now, it's not a total free-for-all, because the law, again, through courts, for the most part, imposes certain safeguards and protections. The primary one is use of trade secrets or other stolen or misappropriated confidential information. First of all, there is a federal statute in place, the Defend Trade Secrets Act, which allows an employer to sue in federal court over the misappropriation of trade secrets, which leads to unfair competition. There's also the common law tort, business tort of unfair competition. New York courts are not okay with employees taking information and then using that information to gain an unfair advantage. Now, what sort of information is protectable is the sort of thing that lawyers fight over. What constitutes a trade secret can be highly debatable. It is not going to get you very far in court to say everything about our business is a trade secret. Generally, courts will say, no, your pricing is not a trade secret because it can be obtained publicly. The identities of your customers is not a trade secret because it can be attained publicly. Your know-how, your general expertise about how to do your business is not a trade secret, and so on. So this is an area where a contract or a restrictive covenant can, if it's written specifically and narrowly, can carve out what constitutes a trade secret that your employees cannot take with them to a competitor. A second major exception is that when your employee is still your employee, they cannot compete with you, ever. What I mean by that is your employee cannot, while your employee can on their own time start a new business and eventually leave and join that business, they can't actively start soliciting clients to join a new business or a competing business. And if an employee does that, even if the employee has never signed a restrictive covenant, then the damages you can get against that employee are pretty dramatic. There's a doctrine in New York called the faithless servant doctrine. That doctrine allows an employer to obtain disgorgement of all compensation paid to the employee, all of it, during the period of disloyalty. and courts are very strict against employees when it comes to imposing faithless servant liability. Again, that requires that the employee is competing while still an employee. If the employee resigns and then starts competing the next day, there's no faithless servant liability. There's also this implied fiduciary duty that employees owe to their employers of loyalty, which could allow you to get damages if your business is harmed some way by your employee, again, while they are still employed. A restrictive covenant can help define what sorts of activity is permissible and not permissible during business hours using your business resources. Finally, if you sell an interest in a business, even if it's a minority interest, even if it's as low as a 1% interest, the law automatically imposes upon you a duty not to solicit the buyer's customers or the customers of your former business. And a court will be much more deferential to any non-compete that is added to the purchase and sale agreement. Sellers of businesses are treated very differently and are protected far less by the courts than employees. Let's go to the next slide. So careful drafting of these covenants is essential because a court will decide whether the covenant is enforceable. We go back to the 1999 case of BDO Seidman versus Hirschberg, where the New York Court of Appeals, our highest court, announced what the standard is for enforcing a non-compete and a non-solicit. BDO Seidman is a very difficult read, and courts have struggled with it and parties have struggled with it for decades. But since we've had a considerable amount of time to digest this opinion, courts have become fairly clear and regular about how to apply it. What we know from BDO Seidman and the court cases interpreting it is that you're very unlikely to succeed if you use blanket catch-all provisions like you can't compete in this region once you leave the business, or you can't solicit any of our clients once you leave the business. A one-size-fits-all restrictive covenant like that is almost certain to fail in court. And generally, the broader the restriction, the longer it lasts, the greater the geographic area, especially if it's regional, the less likely that a court will enforce it. Let's go to the next slide, please. Lawyers have tried many ways to get around the restrictions on these non-competes and non-solicits, and they generally don't work. So a high-profile failed effort to find a loophole was to try to apply another state's law in the non-compete. In this case, Florida law, in a case that went up to the Court of Appeals called Brown and Brown. So Florida law is a lot more employer-friendly than New York law. Well, the courts said, no, we're not going to apply Florida law at all because we find it is truly obnoxious to New York public policy. It's too harsh on employees, so we're going to apply New York law instead. And the restrictive covenant eventually got struck down after years of litigation. There's lots of language that lawyers and their clients put into these contracts to try to make them more likely for courts to enforce them, and they have the opposite effect. Courts look at this language and they say, no, this language shows that we should not enforce the restrictive covenant because it's going too far. It is, and as my last point says, you cannot look at any case and intuit how to write an enforceable restrictive covenant. It takes knowledge of over 20 years of cases to know what will work and what will not work. Because it is not set out in any statute or easy to find single place. Let's go to the next slide, please. So restrictive covenant litigation is high stakes because what an employer wants to do is immediately stop the violation of the restrictive covenant. Sometimes employers bring a garden variety lawsuit for damages, for money damages, and they litigate it conventionally. But what employers commonly want to do is seek injunctive relief at the beginning of the case. That means when you sue, when you draft a complaint, you also want your counsel to draft a motion for a temporary restraining order and a preliminary injunction. And that makes your litigation very front-loaded, because your counsel now has to prepare a detailed motion that includes affidavits from you, the employer, that establish what the contract is, who the employee is, and what the employee did in violation of the contract, and crucially, the consequences to the employer. It is not a matter of just saying to counsel, let's stop our employee from competing. It's a drastic remedy, and it needs to be treated like a significant legal endeavor, and it requires a great deal of buy-in and collaboration from employer clients. It's a lot of work, but if you get it, it pays off, because it essentially has a case-winning effect. If you get that preliminary injunction, then the court will force the employee to abide by the terms of the restrictive covenant for the entire litigation. That means that all solicitation in violation of the covenant has to stop. All competition in violation of the covenant has to stop. That is, again, the kind of win that often resolves the entire case. The employee is placed in a position where they generally have to reach some kind of binding settlement and stop the prohibited activity. The reverse is also true, though. A decision that to deny a preliminary injunction can have a devastating consequence for the employer, because the court will likely say something like, the court finds this restrictive covenant likely to be unenforceable, and will issue a pronouncement that if the case were to go forward to conclusion, the employer would likely lose, and the restrictive covenant would be struck down. Let's go to the next slide, please. So the bottom line is, if your restrictive covenant was not recently drafted by an attorney that has specialized knowledge of this area, there's a good chance it won't pass muster. There's a question in the chat about whether court rulings are uniform throughout the state, and or whether there are certain regions where it's harder to win than others. And I would say that generally the answer is the courts are uniform. The courts have coalesced around not enforcing restrictive covenants unless they contain very specific language, and also omit very specific language that courts don't like. Another problem with this situation for employers is that what's supposed to happen if the court looks at your restrictive covenant and says this can't be enforced the way it's written, the court's supposed to engage in a analysis to see if it's okay to narrow the restrictive covenant and apply it in a more specialized way. But it is increasingly common that courts will refuse to do that, because courts will say, oh, you've known the rules since 1999 because of that BDO Simon decision. It's been so long now, there's no excuse for your failure to get your restrictive covenant in line with BDO Simon. Well, of course, there really is an excuse. BDO Simon is impossible to understand, but that's not how courts see it, right? Courts see it as far too late for employers not to have their restrictive covenants drafted properly. So getting a court to narrow your agreement rather than throw it out entirely is increasingly unlikely. So to conclude, this is an area where we can help. I'm frequently revising restrictive covenants for employers, and I'm happy to weigh in on whatever you've got, or if you don't have something in place, I'm happy to help put something together for you that's something that you can take to court and feel confident about.
Jeremy, thank you so much. That's really good practical advice for any employers that either want to hire someone who has a potential restrictive covenant in place, and for those employers who want to use restrictive covenants for their existing employees. Okay, last but certainly not least is Lacey Miller. Lacey is an attorney in our intellectual property group, and she's going to talk to us a little bit about public performance of copyrighted works. Lacey, welcome.
Thank you, Adam. Thanks for having me. You want to go to the next slide, please? Thank you. This topic in general has been coming up more and more recently as businesses have been receiving letters from certain licensing entities in specifically the music industry and the video or television industry, saying that they have been publicly performing copyrighted works within their business in violation of copyright laws. So the Copyright Act does provide copyright owners the exclusive right to perform their copyrighted works publicly, which applies to literary, musical, dramatic, choreographic works, pantomimes, motion pictures, and audiovisual works. It does not apply to pictorial, graphic, sculptural, and sound recordings, mostly because you can't perform a work of art, and the sound recording is usually copyrighted. The music, the underlying music or other aspects of that is recorded, and there are some caveats for sound recordings in general. So to avoid violating this law, you need a license to publicly perform the copyrighted works. And if you don't, the violations of that can be range from $200,000 to $150,000 per work. Next slide, please. So what exactly constitutes a public performance? In general, courts and the Copyright Act has determined that everything is performance. They've defined performances to recite, render, play, dance, act, pretty much everything, including singing in the shower, which the Supreme Court has said is a performance. It is not done publicly, hopefully, so they have made that distinction. And that's really what the law comes down to, is what is being performed publicly. And to perform or display the work at a place open to the public, or at any place where a substantial number of persons outside of the normal circle of family and social acquaintances is gathered. This can also include clubs or places that are membership restricted. Courts have also been known to say that multiple viewings or multiple performances in a row, even if they were small groups here and small groups there, are cumulative, and then it is a public showing, even though you're only watching with maybe 5 people at one time. This also includes the transmittal or other communications of performance, so streaming or sending the performance to a device or entity or the public, or even if the public does not download it, if they have a way to download it. So next slide, please. There are some exemptions to this. For example, certain face-to-face teaching activities. If you were to show a movie or play certain music, especially in the educational nonprofit industry, face-to-face, there are some exemptions for that. Nonprofit performances, works of a religious nature in a place of worship are exempt from this, and certain establishments can be exempt from the requirement of a license, such as having certain size requirements for restaurants that's less than 3,750 square feet. That's gross square feet, including some outside space. Or there's if you have 3,750 square gross feet of space, and then very specific requirements about the number of speakers, the spacing, the size of your television and spacing. It's you might be able to avoid a license or the requirement of a license in certain aspects like that. Next slide, please. However, in general, the way that you can avoid being violated or fined in these aspects is to either only play works that are in the public domain, so anything that's not currently copyrighted, or to obtain the appropriate licenses. In this case, that can be done through licensing entities There are different licensing entities for certain music aspects. There's also different licensing entities for video and television companies. Or another way that a lot of businesses can get around this is to use a proper business service provider that does that licensing work for you. So for example, if you're playing Pandora or Spotify in your waiting room or your business, you can 100% be in violation of copyright, and this is commonly where people are receiving the letters. But if you're using the Pandora business subscription that they have done the work of going through and getting the licenses for you within that service, there are some ways that you have the benefit of that license. However, if you're playing the personal service in your business, that is definitely within violation, and then you'd have to have the other specific license from a licensing entity or from the copyright provider. We would recommend you monitor compliance with the copyright law. In certain circumstances, you may have a license for certain copyrighted material, but not all copyrighted material. These licensing entities commonly only provide for certain musicians, certain songs, or things like that. So you have to monitor what is being played. And if you have the appropriate license, you should incorporate and adopt a good written copyright policy that is being monitored and updated regularly, and to make sure that your employees have been properly educated on the copyright law and what is happening, especially if they are the ones making the decisions on what is being played in the business. And I think that's all.
Lacey, thank you so much. Thank you to everyone that joined us today. As always, we appreciate you being with us on Tuesdays at noon. If you have any suggestions, any topics, please let us know. We will certainly incorporate them. Great to see you all, and we will see you back here again next Tuesday. Thank you.